Case numbers 24-00327 FY and 24-00328. These are both matters of Joseph Bernard Murphy. The first matter is State of Michigan versus Murphy. The second matter, City of Royal Oak versus Murphy. Mr. Angot, your appearance, please.
Thank you, Your Honor. John Angot appearing on behalf of Joseph Murphy as to both cases, Judge.
Thank you very much. And Mr. Angot, the court makes judicial notice of some extenuating circumstances of a health and safety nature, but given that fact, have you actually consulted with Mr. Murphy to the best of your ability?
Judge, I believe, well, I have to the best of my ability, based upon Mr. Murphy's limited reactions, I believe he understood what I had conveyed to him. I did tell him about the charges, that being 4 total separate charges, 3 within the first complaint and the malicious mischief as to the second case. I did also tell him about the potential penalties as to each. However, Judge, just so this record is clear, I would respectfully ask the court for a formal reading, after which I would stand my client mute as to all 4 counts.
Very well. As to case number 24-00327, people of the state of Michigan versus Joseph Bernard Murphy, it is indicated as follows. Count 1, Mr. Murphy did commit the crime of larceny in a hospital by stealing a wallet, driver's license, credit cards, house keys, and car keys, contrary to the statute so made and provided against the peace and dignity of the people of the state of Michigan at Michigan Compiled Law 750.360, a 4-year felony or $5,000 known as larceny in a building. Count 2, Mr. Murphy is alleged to have knowingly made an open or indecent exposure of his person, contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent A of the Penal Code. That is a 1-year misdemeanor and or $1,000 known as indecent exposure. And count 3, Mr. Murphy was a disorderly person, to wit, he engaged in indecent or obscene conduct at Walgreens located at 3852 Woodward Avenue, contrary to the statute so made and provided at Michigan Compiled Law 750.167, subparent 1, subparent F, crime known as disorderly person, punishable by 90 days. With respect to the city ordinance case 24-00328, that is written under Municipal Code Chapter 278, Section 15B, known as malicious mischief, inasmuch as Mr. Murphy is said to have willfully and maliciously destroyed or injured another person's house, barn, or other building or its appurtenances with the amount of destruction or injury totaling less than $200, to wit, the cell number 6 of the Royal Oak Police Department. Those are the charges in their total. Any questions related to the reading, Mr. Angot?
No, Your Honor. Thank you for that formal reading. As to each count, as noted earlier, I would stand my client mute and ask the court to enter a plea of not guilty.
Not guilty pleas are entered on each and every one of these counts on behalf of Mr. Murphy for the request of his MIDC counsel, Mr. Angot. The court is at some loss as to how to notify him of his probable cause conference. So we'll simply make notice of the fact that the next proceeding on the felony matter with its accompanying misdemeanors will be a probable cause conference set within this court and assigned to Chief Judge Derek Meineke, and a counsel assigned by Mr. Mena's office, IDSO, will be doing their best to meet with Mr. Murphy per the MIDC standards 1 through 8 so that they can assist him as best they can. With respect to the city matter, that will be set for a pretrial, and presumably, Mr. Angot, the court will not invade your bailiwick. You would be obviously free to appoint anyone that meets your particular standards of your offices.
Thank you.
That leaves us as to bond. Bond is not intended to punish Mr. Murphy, but is required in order to ensure his reappearance to court and afford any necessary protection for the public. And in that regard, knowing what we can actually take some judicial notice of, Mr. Angot, I would defer first to any remarks that Detective Peltier may make, and then obviously you have the floor as to what you wish to convey to the court in the context of bond.
Yes, sir.
Thank you, Your Honor. Dan Pelletier for the Royal Police Department. I'd ask the court to consider the fact that Mr. Murphy has no address, phone number, or email, as the court stated. There's no way to get in contact with Mr. Murphy or advise him of his new court date. The police department does have concerns that he will not show up for court. The primary concern for the police department is the safety of the community and the public should he be released pending further issues or pending further appearances in court. Everywhere that he was at on the 14th of February of this year, he victimized someone either through theft, exposing himself, or making obscene gestures, or a culmination of several of those things, as he not only exposed himself at the gas station known as Mobile at 13 Woodward, but stole property from that venue as well. He also has a criminal history, which includes sexually deviant offenses, as well as outstanding warrants for his arrest that he didn't go to court on for offenses either involving sexual deviancy or exposing himself, specifically urinating in public. So, Your Honor, I would ask the court impose a significant cash bond to assure both his appearance in court and the safety of the community and the public.
Thank you very much. Mr. Angot, what would you like this court to know related to Mr. Murphy's bond, his reappearance to court, his ties to the community, his comportment and health, and his ability to so comport himself to the rules of society?
Judge, I'll note a couple things, if I may, regarding notice to Mr. Murphy as to future dates. He is obviously in lockup next door. This court, your court, can certainly produce a court date prior to his release, so he could be actually served that date while he's in custody next door. And going forward for future dates, certainly the court, I believe, would accommodate him by setting those dates either from the bench or downstairs on the same day that he is to appear each time going forward. He can get those dates on those same dates of appearance for the next appearance. That being said, Judge, I believe it's clear that Mr. Murphy defines indigency. He does not have a dime or a dollar to his name. Setting bond at anything beyond a personal bond is an impossibility. It is no bond. And so I would ask the court to take that into consideration. I understand the gravity of the offenses and the issues that we're basically looking at on the screen there, but I would ask, I can only ask that, Judge, because he has, I don't believe, any family members or anybody who would step up and be able to post any kind of monetary bond. And so you could set it at $1, Judge, and I believe he'd sit. So I'd ask for a personal bond to give him the opportunity to get back out to defend himself going forward.
Thank you very much. Mr. Angot, just so that the record is clear, first, is there anything else you wish to make a record of respective of the procedures up to this point?
No, Judge, I believe that I don't know specifically if you're alluding to anything, but I would say this, that I believe my conversation with Mr. Murphy um, was successful in the sense that I related to him the nature of the crimes, the charges themselves, the possible penalties. I asked him if he had any questions. I went through his constitutional rights as to trial. I talked about a statutory right as to preliminary examination for count one on the first complaint. Um, and he seemed to understand because he didn't ask any questions that really related to his misunderstanding of any of those issues. So I think we're good to go forward. The next council may have better communication with my client to understand if there's any kind of need beyond just going forward today.
Thank you very much for those remarks. And based on your training experience, first, do you have any reason to believe that under standard operating procedures, any council that is sanctioned by the MIDC through the IDSO office would have any, strike that, would willfully fail to obey the MIDC standards in appropriately counseling Mr. Murphy?
No,
All right.
absolutely.
So you don't believe that it's impossible for him to prepare his defense while he's in custody?
Judge, if my interaction with Mr. Murphy, which was obviously not extensive, I'll put it that way. It was brief in the sense of I'm representing him only for this arraignment this morning. My belief is that yes, he will be able to successfully communicate with his MIDC attorney going forward, and the standards certainly will be met by that attorney in his representation or her representation of Mr. Murphy.
Thank you very much.
Yes, sir.
And although none of us can foresee the future, it wouldn't be considered an exotic or unreasonable request if at some juncture his defense counsel, with or without the stipulation of the people, might be mindful to refer this matter to the Forensic Center for Psychiatry. Is that
Judge, based
foreseeable
upon
situation?
Yes, I think based upon this morning's events, I think that's foreseeable.
All right, thank you very much. The court has heard the arguments as to bond. The court has made a formal reading in each and all of these matters. With respect to case number 2400327, the following conditions will apply to any potential release. Mr. Murphy will appear as directed for his future dates. He'll abide any valid order or judgment entered in this case. He will not leave the state of Michigan without permission of the court. He will not commit any crimes while he's on release status. He will notify the court of his address immediately upon securing an address, whether that is at a healthcare facility or otherwise. He will be required to submit to supervision by pretrial services. He will not use alcohol, marijuana, or any other controlled substance. He will participate in a substance abuse testing program. He will also, if he makes his liberty, participate in any specified program as recommended by the RISE Center. So if he is released for whatever reason, he is to report to the RISE Center on the 1200 campus before he goes anywhere else. He will not be released without a GPS tether. He will submit to 2 ETGs per week and 4 controlled substance tests per month. He will not have any contact with a Mary Stanford, a Delray Bryant, or a Nina Pica. He will not enter the city of Royal Oak for any reason other than court or medical treatment. He will not visit any CVS, Walgreens, or mobile filling station anywhere in the state of Michigan. He will not purchase or possess a firearm or other deadly weapon. And the bound amount at this time for this matter will be $75,000 cash, surety, or 10%. These self-same conditions will apply with respect to case number 2400328. And the bond amount in that matter will be $25,000 cash, surety, or 10%. Mr. Angot, do you have any questions about any of these proceedings up to this juncture or the bonds as they have been set?
No, Your Honor.
Very well. The court makes the finding that security staff is doing their best to avail Mr. Murphy of his full ability through the Zoom portal to participate in these matters. However, it does appear to be posing some health risk to staff in terms of passing a device back and forth. So the court makes that finding as well. Anything further, Mr. Angot?
Nothing further. Thank you, Your Honor.
Anything further, Detective Peltier?
No, Your Honor. Thank you.
That closes this arraignment. Good luck, Mr. Murphy.